But the real break came miles away when a different police agency put cutting-edge facial recognition software to the test.
But that there are new policies in place that they will from now on only use facial recognition for violent crimes and home invasions, that every identification through facial recognition is going to require two experienced examiners to ratify it. But he did not want to throw the technology out with the bathwater. He says it can be useful. We heard this also from Detroit Mayor Mike Duggan.
I'm like, hello? The guy's talking like he knows me. He's Robert. And I'm like, who is this? You need to come down and turn yourself in. Who is this? Officer, somebody from the 3rd precinct, and I need to turn myself in for what? So he's like, I can't tell you that. I'm like, then I can't come down. Well, if you come down, it'll be much easier on you. You don't want us to come out to your job, do you? At this point, I think it's a prank call. So I'm like, look, man, if you want me, come get me, I'll be at home. Bring a warrant. And I hang up on him.
Beautiful, isn't it?
Beautiful, unethical, dangerous.
Hello, and welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Thank you for joining us on this Memorial Day, and we hope that you are having a happy and safe holiday. Law enforcement agencies across the country are beginning to use facial recognition technology in order to grant them probable cause to make arrests and crack down on alleged criminals. But does it actually work, and is it constitutional? Is this a question of the government attempting to use the most modern technology to help keep us safe? Or is it another method of control designed to plunge us further into an Orwellian dystopia? A subscriber reached out to us and asked us to evaluate what are the accused rights when faced with an arrest that was predicated upon facial recognition technology, identifying that person as the alleged perpetrator of a crime. First, we take a look at a news story from a little under a year ago in Albuquerque, New Mexico.
He's a suspected shoplifter who thought he could get away with the crime until facial recognition software put an end to his plans. Now, newly released police video shows the moment police finally caught him. News 13's Jeannie Nguyen shows us.
It didn't take long
he's outside.
For staff at Albertsons on Montgomery and San Mateo to recognize Anthony Senna back in February.
Hey, come here. If you walk away from me, I'm going to chase you off and put charges on you.
Police say the 23-year-old has been accused of trespassing and stealing for the last 7 years at stores across the city.
Stop, man! What are you doing? Stop! Come on, man!
Senna led police on a chase after the store's front door security camera caught him with the facial recognition software. Senna kept running from officers and even narrowly missed getting hit by oncoming traffic on Montgomery. But the chase didn't last long.
Get on the ground! Get on the ground!
After officers cuffed him, he insisted he did nothing wrong.
I didn't do nothing, guys. Doesn't matter. You see this?
Yes.
That means if I tell you stop, you stop. You're under arrest, by the way.
And continued on with the act.
You know you're not supposed to be at Albertsons. You know you're not supposed to be.
What do you mean? Stand up. Yeah,
Stand up.
you've been trespassed.
Okay, but you've been CT'd from this.
No, I haven't. That's not
Okay,
right.
well,
That's not true.
Once they get back to the store, Senna seems to be in disbelief when an employee tells him they've been watching him.
Yeah, no, we've never actually caught you in person, but we know who you are.
Jeannie Nguyen, KRQE, News 13.
Senna was only charged with resisting arrest for this incident, and the DA's office dropped the charges, claiming there wasn't enough evidence.
So a lot of things went wrong here that are not even related to the main topic of facial recognition technology. The officers were called by the store to arrest a man for trespassing who the store had not even spoken to about being trespassed. So they chased the man for trespassing who had not even been trespassed. And thus the charges were thankfully dropped, except for that resisting arrest charge. However, in this instance, is the use of facial recognition technology by the grocery store to enforce its trespassing policy legal, or does it violate your constitutional rights? The store is a private entity that is opening its facility up to the public for business. Just like you have the right to film on your own property, the store can do that too. They can also use whatever technology they choose to enforce their policies as long as it does not violate some other law. For example, Most states allow stores to use surveillance cameras in dressing and fitting room areas as long as the customer has at least informed consent. Some states do require that the customer gives express consent, but all of these require that the surveillance is only used for theft prevention. So yes, the store would be allowed to use facial recognition technology to enforce a trespassing policy, and they can legally watch you as you shop. But now we get to the heart of the question, which is, can law enforcement use facial recognition technology to hunt down alleged criminals or to gain probable cause for crimes that were caught on camera?
But the real break came miles away when a different police agency put cutting-edge facial recognition software to the test. News 6's Eric Sandoval shows us how that quickly got crime results.
Clermont police enlisted the help of their own residents in trying to track down these thieves, but it was actually investigators from other agencies who happened to be trying out new technology that helped them track down at least one of them. November 20th, surveillance cameras at the Ace hardware store here on Highway 50 in Clermont capture these two people. Clermont police investigators say the store managers saw them loading up their pickup truck with more than $1,000 worth of grills and a shop vac. Their investigation hit a snag, though, when the license plate number didn't match the vehicle. So Clermont police posted these pictures on social media, hoping someone would recognize them. The Seminole County Sheriff's Office saw those pictures and tried another approach, turning to new facial recognition software they're testing out. The software is similar to this, where a screen grab of a person's face is run through a database containing hundreds of thousands of mugshots of people with previous arrests. It came back with a match: 31-year-old Heather Reynolds. Tampa police also put their software to the test, and it came back with the same name. Investigators say the software even revealed what the mystery tattoo was in the surveillance picture. We checked, and Reynolds has faced a handful of arrests over the last 3 years. She's been booked on grand theft, retail theft, and resisting arrest. Clermont police arrested her again this week, and once again charged her with grand theft.
The Supreme Court held in Katz v. United States that the Fourth Amendment to the United States Constitution protects individuals who have reasonable privacy interests. The test established to determine if a privacy interest is reasonable or not evaluates first if a person has exhibited an actual subjective expectation of privacy in a public place, and second, if that expectation is one that society is prepared to recognize as reasonable. In this case, law enforcement had a video of the alleged crime being committed, then ran the face of the alleged perpetrator against a database of people who had already been arrested. The alleged perpetrator did not really exercise any type of behavior that would suggest that she had a reasonable expectation of privacy, as she was allegedly stealing grills from the Ace hardware, a public place. As we have discussed many times before, anything you willingly expose to the public arena is legally allowed to be filmed by others, whether it be by the police, a store, or a First Amendment auditor. Further, mugshots and other information gathered from law enforcement at the time of an arrest are not examples of information that has a reasonable expectation of privacy and are used on a regular basis during criminal investigations. We'll talk more about that later on in the video. However, evolving technology is allowing law enforcement to intrude upon the private lives of Americans at an alarming rate. Using devices to gather information in ways that would have been in the realm of science fiction back when the Fourth Amendment was originally penned. The Fourth Amendment's protection from unreasonable searches and seizures still applies even from new technology. In Kylo versus United States, federal agents believed that Kylo was operating an illegal marijuana grow operation in his home. This type of operation generally requires heat lamps that generate a lot of heat. The agents then used thermal imagers to scan Kylo's home to determine if there was an abnormal amount of heat emanating from his home that would indicate that he was using heat lamps that would be consistent with that of a marijuana grow operation. The thermal scans showed that Kylo's house was substantially warmer than neighboring homes, and they were issued a warrant from a federal magistrate based on the scan, tips from informants, and utility bills to search the home for contraband. The Supreme Court drew a rule that states that if the technology used to conduct the search is not able to be used by the general public, then that technology cannot be legally used to compile evidence without a warrant. Therefore, the use of the thermal imaging device was unconstitutional, and the search was invalid if based on the information provided by the thermal image scan. With the Katz and Kylo rulings as our guide to interpret the Fourth Amendment's protection from being videotaped in public, and then having that image ran through government databases, we can evaluate how the police can use this technology legally and see an example of what happens when they get it wrong.
So when we get to the interview room, the first thing they had me do was read my rights to myself and then sign off that I read and understand my rights. A detective turns over a picture of a guy inside Shinola, and he's like, "So that's not you?" I look. I said, "No, that's not me." He turns another paper over. He said, "I guess that's not you either." I picked that paper up and hold it next to my face. And I said, "This is not me." I was like, "I hope y'all don't think all black people look alike." And then he says, "The computer says it's you." At that time, no. I didn't know that they used any type of facial recognition or anything like that until talking with the detectives who showed me that that's what they used to apprehend me, if that's the right word. It's just a boring Thursday, right? We're on the phone with Lissa around 4. So then my line clicks. I click over. I'm like, "Hello." The guy's talking like he knows me. He's Robert. And I'm like, "Who is this?" "You need to come down and turn yourself in." "Who is this?" "Officer, somebody from the 3rd precinct. And I need to turn myself in for what?" So he's like, "I can't tell you that." I'm like, "Then I can't come down." "Well, if you come down, it'll be much easier on you. You don't want us to come out to your job, do you?" At this point, I think it's a prank call. So I'm like, "Look, man, if you want me, come get me. I'll be at home. Bring a warrant." And I hang up on him. I was completely shocked and stunned to be arrested in broad daylight in front of my daughter, in front of my wife, in front of my neighbors. I can't really put it into words. It was one of the most shocking things I ever had happen to me. Some detectives came to see me. They took me out of the cell and to an interview room. And then they was like, "Would you like to make a statement?" And I'm like, "I don't even know what's going on." Guy says, "If you don't sign off saying that you want to make a statement, we can't give you any information." So I signed to say I'm going to make a statement. He laid the papers out on the table. And at that time, I was still guilty in their eyes until the pictures don't match. And they left them on the table and they looked at each other like, "Oops." It says, "This is used only for investigative purposes and not to arrest." If he'd have just brought the picture with him, he could have looked it up and down and he could have left and said, "Oh, my bad. I didn't mean to bother you." They just pulling pictures from everywhere, matching you up from anywhere from social media to, I guess if you're in the background of a picture and it's a clear picture of you, they can use that. And it obviously doesn't work.
This is where the law enforcement agency gets it wrong in this case. I do believe, based on current Supreme Court precedent, that it is constitutional for law enforcement to use facial recognition technology in some situations. It is making use of video surveillance that almost everyone has access to, and facial recognition software that is widely accessible to the general public and becoming more accessible every day. So I do believe that facial recognition will be found to be constitutional as long as the information from the software is ran against a database of information that would not be reasonably private information or accompanied by a search warrant. The Supreme Court has held in multiple cases that it is not an unreasonable seizure for law enforcement to capture your fingerprints, photograph, and DNA upon arrest. Further, they have also ruled that it is not an unreasonable search to use these identifying items by placing them in a database and running checks from new crimes against it. This is not a violation of the Fourth Amendment per the Supreme Court because these are items that are not reasonably private according to them. However, where I believe this case violated Robert Williams' constitutional rights is when they ran the picture of the alleged thief not just against individuals who had been arrested and subjected to submitting a mugshot, but also everyone who had obtained a driver's license or an identity card in the state of Michigan. Your identification and the information contained on your ID is information that is reasonably private, and you subjectively have a reasonable expectation of privacy too, and I believe that the general public would be willing to accept this as a reasonable expectation of privacy. Therefore, the use of facial recognition technology by running it against a database of people who have not had a mugshot to compare it to is, in my opinion, an unconstitutional and illegal use of this technology. Further, there has to be safeguards put in place to protect us from wrongful accusations, arrests, and convictions. Information from facial recognition software should be given the same amount of credence, if not less so, than portable breath tests or lie detector tests. These are not admissible in court and not the sole justification for probable cause to make an arrest, just merely an investigative tool to help law enforcement find the alleged criminal. These have to be the bare minimum safeguards when law enforcement is using facial recognition technology. Again, this is what I believe will be the constitutionality of the use of facial recognition software in our society based on Supreme Court precedent. I, however, agree with Lucius Fox in The Dark Knight when he says that this type of technology is immoral and dangerous. This type of power is easily corrupted and manipulated to hurt people and to trample upon individual liberties. I hope that we can vote into office legislators who see the need to protect the people from an overreaching government that wants control and authority over our daily lives. What do you think? Are we headed into an Orwellian dystopia? Are we already there? Or do we still have a chance to preserve our freedoms? Do you think it's completely reasonable for law enforcement to use facial recognition technology however they want to? Let me know what you think in the comments below, and we'll see you next time right here on Legal Dissent.